This evidence hypothetical could serve as a template for all evidence essay questions on every bar exam ever given. This is about as standard a question as you can hope for. Take a look at the call of the question, and it reads, assuming that all objections were properly made, should the evidence objected to in items 1 through 5 have been admitted? Discuss. It's obviously an evidence question. A quick glance at the page reveals that there are 5 items of evidence. We realize that we've got 5 short answers to write, in however much time they give us to write about them. The issues presented here are very standard issues, and they are presented in stereotypical ways. You can almost change the names of the characters and see this examination question present all across the country. Go to the top of the question, and the setup is clear and simple. We're in criminal court. Dave is on trial for arson, defined by statute as setting a building afire either intentionally or with gross and reckless disregard for human life. So we're alerted, just by looking at the heading, to be sensitive for criminal procedure issues. And as it turns out, there aren't any. This is a straight evidence problem. Let's glance through and see if we can issue spot this quickly, and then we'll take a look at a more elaborate explanation of the issues presented. What we're looking for is a quick way to fill in our basic outline. We're going to assign a Roman numeral to each one of these 5 items of evidence. Letter A for our analysis under each one of these 5 will be logical relevance. And then we're going to try to identify as many applicable objections as we can, and then we'll focus on the analysis. So for issue spotting purposes, what we're basically looking for here is objections. We look at item 1, we see the prosecution has called a witness, Sam, a cook, who testifies that he heard some other waiter run into the kitchen, shouting that Dave was spilling gas in the lobby and somebody should call the cops because they're all about to die. And this guy can't be located. Clearly, this is a hearsay problem. We might also suggest that there is an aspect of opinion present here, but basically it looks like a hearsay issue. In item number 2, we find out about Ellen, a prosecution witness who testifies that Dave has been a busboy at the grill before he was employed at Cafe, and that she had fired him after she had caught him teaching other employees how to construct a bomb. It's apparent that this is a character issue, specifically prior bad acts. Now, in item number 3, we've got the defendant taking the witness stand on his own behalf. He testifies that he had been ordered to clean the lobby floors and brasswork, and that he was using gasoline as a cleaning solution when a patron entered and flipped a lit cigarette butt on the floor, igniting the gasoline. Now he is on cross-examination after that. And over objection, the prosecution elicited the fact from Dave that 2 years earlier he'd been expelled from college for cheating on a final examination. It's clearly a character issue, but we observe that we've got a criminal defendant taking the stand, responding to a question from the prosecution on cross. Next, we turn to item 4, and we've got a chemist testifying over objection that, in his expert opinion, although use of gasoline as a cleaning fluid can't be recommended, it should be reasonably safe. Clearly, this is an expert opinion issue, and about as straightforward an expert opinion issue as you can expect ever on an exam. Finally, we turn to item 5. This is a judicial notice question, and it's apparent that the prosecution has got the court to go a little too far. This finding of judicial notice impermissibly shifts the burden of proof away from the prosecution. So flip the page and turn a look at how I've chosen to outline the issues presented here. You'll see that I haven't diverted from the basic approach. I've assigned a Roman numeral to each item of evidence. The first step for each item is relevance, and I focus on the various objections that appear to be at issue. Ultimately, I reach a conclusion. Once again, I suggest that the lawyer's work here is organizing and outlining how you're going to work your way through this answer. Actually writing the answer is somewhat closer to what a paralegal or a law clerk would do. So now let's take a moment to carefully review the issues presented by this very straightforward, very standard evidence problem. We start off with item 1, which is Sam's testimony about Bart's statement. According to Sam, Bart shouted that Dave was spilling gasoline all over the lobby. This is relevant because it suggests the defendant is guilty of intentionally setting fire to the cafe. But Sam is quoting Bart's out-of-quote statements for their truth. They are hearsay statements, but they will be admitted under one or more exceptions to the hearsay rule. Bart's statements qualify as an excited utterance because they were made at a time when Bart was agitated and thus less likely to fabricate. The prosecution would also contend that Bart's statements qualify as a present sense impression, since he had just seen Dave spilling gasoline seconds earlier. This is the less applicable exception, but it might work to admit Sam's testimony. Sam also quotes Bart as shouting that Dave was going to kill us all. If this statement is admitted, Dave's criminal mental state may be established. The defense will argue that this statement is improper opinion because it exceeds the scope of permissible lay opinion and goes to the legal interpretation of Dave's conduct. A person in Bart's position could be expected to hold this opinion. It was probably not an abuse of discretion for the judge to admit this part of Sam's testimony. I would conclude that the testimony is admissible. Bart cannot be located by either party. This fact is irrelevant to the outcome of the analysis. His statements, quoted by Sam, are admissible under the excited utterance exception to the hearsay rule. Now we turn to item 2, Ellen's testimony about firing Dave. Ellen testified that she fired Dave from a prior busboy job after she caught him showing other employees how to construct a gasoline bomb. This testimony is relevant because it suggests defendant is an arsonist who knows all about making fires from gasoline. The testimony suggests that Dave is guilty as charged. The obvious objection is that this is improper character evidence of prior bad acts. Dave has not yet opened the door to an examination of his character, as Ellen's testimony is being offered in the prosecution's case-in-chief. The judge must exercise care that the jury is not allowed to make an easy inference of defendant's guilt of the charged offense based on evidence that defendant is evil. The prosecution might be able to get this evidence in for another purpose so as to show the absence of mistake or motive, intent, etc. It's conceivable that the mimic rule would allow it in. However, I conclude that this evidence is more prejudicial than probative. Dave is not accused of using a gasoline bomb in this case. Ellen's testimony does not tend to show that David had a standard method of committing arson. It merely suggests he likes to set fires. As such, probably it's more prejudicial than probative, and the judge was wrong to admit it. We turn next to item 3, Dave's testimony about using gasoline for cleaning. Dave testified that he was following orders to clean the lobby doors and brasswork with cleaning solution that included gasoline. Dave also testified that the fire was started by a careless patron who flipped a cigarette butt onto the lobby floor. The testimony is relevant because it suggests defendant did not have the criminal intent needed to be guilty of arson. The prosecution could argue that the first part of Dave's testimony relies on hearsay, the alleged instructions of Dave's supervisor. This is a weak argument because Dave is not quoting his instructions but merely indicating they had been issued. The effect on the listener exception to hearsay or the state of mind exception probably would admit an even more specific quote than this one. Next, we examine the cross-examination of Dave about being expelled from college for cheating. As discussed above, prior bad acts evidence is not admissible unless the defendant opens the door to an examination of his character. Arguably, since Dave wants the jury to believe that his alibi is truthful, the prosecutor has a right to inquire about past instances in which Dave has been dishonest. The expulsion happened only 2 years ago, so it is not so remote in time as to be irrelevant. Dave admitted the facts. The prosecutor would not have been allowed to bring in extrinsic evidence of the expulsion if Dave had denied it under cross-examination. I conclude that both the direct and the cross-examined testimony were properly admitted. So, we turn to item number 4, Dr. Hicks's testimony about gasoline being reasonably safe when used as a solvent. Dr. Hicks is a defense chemist who was called in to testify that defendant's conduct was reasonable under normal circumstances. This testimony suggests defendant did not have reckless disregard for human life, and therefore is innocent of the present arson charges. Obviously, the objection is improper expert opinion. Dr. Hicks appears to be qualified to offer expert opinion because of his education, his review of the literature, and his ability to conduct independent experiments on issues within his expertise, so long as his methods are generally recognized in the field. The jury could evaluate the merit of his testimony under cross-examination and based on their own evaluation of his credibility as a witness. The real issue is whether or not the opinion expressed by Dr. Hicks requires any expertise at all. It is common knowledge that exposing gasoline fumes to burning objects is dangerous. The prosecution will contend that Dr. Hicks merely has been hired to offer a pseudoscientific justification for Dave's conduct. I conclude that the issue could have been resolved either way. The prosecutor's argument that there was no need for expert opinion to help the jury understand the technical issues involved has merit. Still, it does not seem the court abused its discretion by allowing Dr. Hicks to offer his opinion. Finally, we turn to item number 5, the court taking judicial notice. A judge is allowed to take judicial notice of specific facts which are common knowledge, or which are subject to easy verification from widely accepted sources. In this case, it would be reasonable for the judge to take judicial notice of the fact that gasoline vapors are very combustible. This is a fact that most people know. The problem is that in this case the judge has granted the prosecution's request to take judicial notice of a legal interpretation of a fact. Here, the use of gasoline as a cleaning fluid constitutes gross and reckless disregard for human life as a matter of law. The judge erred. It should be left to the jury to decide whether or not the defendant exhibited gross and reckless disregard for human life. Dave has offered evidence which could support a finding that he did not have that mental state. The jury should be allowed to evaluate all of the evidence. And that concludes a review of a very straightforward, very standard evidence hypothetical. You're likely to see issues just like these on the multi-state bar exam, and they could easily appear on essays as well.